23, Lord, may I? 23, Mr. Tanka is not right when he submits that the governor would be sitting in appeal over the decision of the Council of Ministers. However, as stated above, unless a situation arises as a result whereof the Council of Ministers disables or disentitles itself, the governor in such matters may not have any role to play. Taking a cue from Antule, it is possible to contend that a Council of Ministers may not take a fair and impartial decision when the Chief Minister or other members of the Council face prosecution. But the doctrine of apparent bias, however, may not be applicable in a case where a collective decision is required to be taken under statute in relation to former ministers. That is the distinction what they have made about former ministers, chief ministers, and sitting ministers.
Ultimately, 33 is what is important.
Yes. Therefore, they hold, of course, not there. They found the persons against whom this sanction was what had by that time ceased to be the ministers, and the cabinet did not have them as part of the decision. Therefore, they said that the theory of apparent bias will not apply. Likelihood of a bias is likely to be, but then they found that it was not
the reasonable
applicable.
Man would think that that's the theory.
My submission, limited submission before your lordship, therefore, is the Council of Ministers, by virtue of the fact that they become interested in the matter, disentitle themselves from any aid and advice to the Council of Ministers. But quickly about the Honorable Chief Minister remaining outside the meeting, therefore, the Deputy Chief Minister presiding over them, I must say that very judgment, interestingly, they quote A.K. Kraipak. But A.K. Kraipak, lordships are aware that Nashband, interestingly, was the chairman of the selection board and had also participated in the selection process.
Apparent bias.
There, my lord, interestingly, Nashband did not participate in the proceedings. May I just request lordships to kindly see the same judgment once again. MP Special Police Establishment, their lordships note this and say still the theory of apparent bias will continue to apply. That Nashband's act, lords, at para 16. This is para 16, they extract para 15.
Yes.
But their lordships, the sentence commencing from, it is true that ordinarily the chief conservator of all that lordships may not refer to. Kindly see from the word. But under the circumstances, it was improper to have included Nashband as a member of the selection body. He was one of the persons to be considered for selection. It is against all canons of justice to make a man judge his own cause. It is true, lordships may kindly note, it is true that he did not participate in the deliberations of the committee when his name was considered. But then the very fact that he was a member of the selection board must have had its own impact on the decision of the selection.
Yes, the word, his bias is likely to operate in a subtle manner.
And therefore, the presence of the chief minister in this case and there must be felt an omnipresent presence, brooding presence, we say, in the hall, wherever this meeting took place. But on this question, lordships will also kindly see Article 163 does not bifurcate between Council of Ministers and the Chief Minister. Article 163, in fact, says there shall be a Council of Ministers headed by the Chief Minister. And in the theory of collective responsibility, etc., lordships are aware of those. The question of Chief Minister bifurcating himself from the decision of the Council of Ministers does not arise. Therefore, on looking at this aspect, the question of the governor consulting or looking into the aid and advice of the Council of Ministers does not arise. But on the question of the second aspect, lordships will kindly see about Principles of Natural Justice, 17A.
Yes, sir.
But there is, of course, before I advert to this, they have cited several judgments, including Shamsher Singh, R.A. Mehta, to say that governor cannot act in his individual discretion, etc., including Nabam Rebi. Of course, all these decisions which their lordships have laid down were in different contexts. For instance, in Shamsher Singh's case, subordinate judicial officer was dismissed by the minister concerned without reference to the governor. They were asked to reconsider Sardari Lal's case, where not for the first time Sardari Lal's case held satisfaction of the president or the governor means the governor himself and not that of the council of ministers. Therefore, Lord, authoritatively they held satisfaction of the president under Article 74 or Lords of the governor under Article 163 must be construed in a democratic polity like ours is to be that of the satisfaction of the council of ministers. Therefore, Lord, the principles of Shamsher Singh was different. In R.A. Mehta's case, Lord, the appointment of Lokayukta was in interpretation of the Gujarat Lokayukta Act, where the chief minister's primacy is there. Of course, now Lord, the law stands settled from a decision arising from this honorable court, Justice Chandrasekhar versus Janagiri Ramaya, where Lord, their lordship said it is the primacy of the opinion of the chief minister which will prevail. Third decision, these are the three decisions which they have cited, is Nabam Rebia. There again, Article 174. The power of the governor to call for a session prorogate. And in the factual situation of that, they said that no, it could not have been done in the individual discretion. Two decisions of the Honorable Supreme Court, similar fact situation as to when the chief minister's complaint or allegation against the chief minister comes, the governor is bound to act independently. Therefore, the decisions may have to be discerned, distinguished in this manner. But on the question of 17A, Lord, 17A on a plain reading, Lord, does not contemplate a notice to the public servant concerned. But whether we can read into that as an opportunity to be given to the public servant concerned before the competent authority arrives at a decision. But I would request lordships to kindly permit me to refer to Subramaniam Swamy versus Director CBI. So it is not that these provisions like 17A or novel. Lordships are aware in number of enactments, Lords, permission to investigate a threshold bar is always there. One of them was Section 6C of the Delhi Special Police Establishment Act, which their lordships, in this Subramaniam Swamy's case, struck down. But one of the arguments advanced by Mr. Anil Diwan in that matter, Lords, I propose to draw that, wherein he says, if you allow this notice to be given to the public servants, etc., concerned at this stage, it would certainly leave the situation for tampering of evidence, etc. Now, may I request lordships to kindly see that judgment? Yes,
Para 14. Sir.
Yes, para 14. I'll read for my satisfaction. Yes. That, of course, I must bring to lordships notice that paragraph, though he advanced that argument, their lordships, of course, struck it down on the ground of Article 14. You can't
it was on a different
bifurcate corrupt officers into joint secretary and above and below. Their lordships held it in that manner. Para 14, I'll just read. Yes. Anil B. Diwan, learned amicus curiae, wants us to take judicial notice of the fact that the high-level bureaucratic corruption goes hand in hand on many occasions with political corruption at the highest level. This very group of high-ranking bureaucrats whose misconduct and criminality, if any, requires to be first inquired into and thereafter investigated, can thwart, defeat, and impair this exercise. In substance, the potential accused would decide whether or not their conduct should be inquired into. He argues the essence of skillful and effective police investigation is by collection of evidence and materials secretly without leakage to the destruction or tampering of evidence and witnesses. Such investigation is compromised by the impugned provisions, namely Section 6A of the DSP Act. But the next sentence, the requirement of previous approval in the impugned provision would mean leakages as well as breach of confidentiality and would be wholly destructive of an efficient investigation.
Yes.
Therefore, my lord, if the argument of the other side is to be accepted, let us take a case where there is an allegation that a document has been forged by the public servant concerned, or any number of illustrations could be given. And the police officer who receives this credible information, or a private citizen who comes to know of it, goes to the competent authority and says, sir, I have come to know about a particular delinquency of a public servant concerned. I want immediate investigation to be initiated. Maybe he be apprehended, search be conducted, these material objects be, the incriminating material be seized. Would stand defeated, my lords, if notice is to be given to the delinquent employee or the public servant concerned. But this is one way of looking at it. And I draw the argument of Mr. Diwan when he argued the DSP Act for the purposes to say that 7A expressly, 17A expressly, consciously excludes notice. One more Lord, perspective about this would be, Lordships are aware, these 17A and 19 came to be amended, but in 2018. For the first time in 2018, when a private citizen files a complaint under Section 19, notice to the public servant is contemplated. Lordships have seen that 19. Lordships are aware that when a private citizen comes to him, the steps are that he goes before the magistrate. Magistrate finds some prima facie case, refers him to go to the competent authority to obtain sanction. He goes back to the competent authority, and then competent authority is obliged to issue notice to the public servant concerned. That is the provision. But the submission which I propose to make before your lordships is, in one stroke, in one legislation, if the legislature has thought it fit to prescribe two different procedures in respect of sanction. One is, of course, a sanction, another is a pre-approval. In respect of sanction by a private citizen, it says that notice is required. In the same amendment, when they introduce 17A, the concept of notice is very conspicuously, consciously silent. The construction of a statute, according to me, therefore, it cannot be stretched to say that the legislature was not aware that when 19 we provided a opportunity to be heard, 17 we do not provide.
19 operates in a different circumstance.
All the time.
Post investigation.
No, all the time. No, all the time I am submitting before your lordship. The concept of hearing. The concept of hearing is afforded in 19. 17A it is not done so very consciously. In fact, I am submitting when the legislature by the same amendment provides two different procedures. Therefore, this aspect that the prior opportunity should have been given does not merit. But there are three judgments. One, of course, the learned Solicitor General has read. That is, that is, lordships will kindly, only one judgment I want to refer to on the question of principles of natural justice in criminal proceedings. That Devanand Singh versus State
Devendra Singh.
Devendra Singh versus State
Devendra Nath Singh.
Yeah, that's the first one, Devendra. May I request lordships to kindly see that page 52.
Para 52.
No, para 52, not page 79.
Yes. What is audio alterum partem in criminal laws?
Lordships get that. Para 50.
Yes, Chadda's case is quoted.
Yes, Vin Chadda's case is.
Vin Chadda's case
Yes.
is quoted. Principles of audio alterum partem as held in Vin Chadda is accepted and said.
They said, therefore, that paragraph, I just wanted to bring to lordship's notice this paragraph. where they quote Winchedda, say, for the present purpose, this is the declaration not by their
Yes.
lordships there.
Yes.
Suffice it to notice that as regard the process and manner of investigation, which included the issue relating to the letter record, the court inter alia pointed out that the exclusion of the principle of audio alternate parties in relation to an accused at the stage of investigation is the following. I will not that para 81.
No, there, the apex court holds, the earlier persons were not investigated into. When you want them to come to investigation later, at a
True.
later stage, you should have given them an opportunity, but not in all cases.
In all
what
cases,
is.
one of the arguments they said that different stages the police should have.
Their circumstance was different.
No, but they they import this concept of audio alternate partem and say that in all cases,
Yes.
in all cases, this principle straitjacket formula cannot be used as a straitjacket formula. Is all that what?
See para 53, next para.
Please.
In fact, it was said that opportunity ought to have been given.
In the peculiar circumstances.
That's
that-
what,
that's
peculiar
that's correct.
circumstances.
Where investigation was being ordered against persons
Yes,
who
who
were
are
not
not
investigated.
investigated.
That's correct. 173 subsection 8, the further inquiry. But Subramaniam Swami, both the Learned Solicitor
They've
General
already-
and
they've already relied on.
Mr. Maninder Singh, para 44, only one sentence of that 44 words, interpreting the same argument there. Whatever the argument which was advanced by Leonard's friend, 19 unamended stood silent on the question of opportunity. They said opportunity should be given. But even at post-investigation, they said, no, it's not possible. They also say that it is the matter of sanction is administrative in nature. It is not quasi-judicial. That is one principle. Second principle is question of notice does not arise. So they will not refuse to read into the principles of natural justice in the unamended 19. It's exactly the argument today before your lordships. Therefore, the concept of issuance of notice does not arise at all, and it would in fact cause prejudice to the sanctity of investigation is my respectful submission to lords.
Yes.
The last limb of this would be whether the public servant concerned at the stage of 17A will have any enforceable right, or the right of hearing would depend on the kind of right which subsists in any provision. But my submission before your lordships is when a complaint or an allegation comes before the competent authority seeking permission to investigate, there is no right